Welcome to the first CIP Forum Overtime webinar. My name is Bo Hayden, and I'm the Director for the Center for Intellectual Property. We created the Overtime webinar series to cover IP topics that our partner firms find important, but were unable to address during our main conference, which we held recently in Stockholm, CIP Forum 2023. Today's webinar is on employee inventorship and compensation in the knowledge economy, which combines areas of technology management, labor and IP law, economics, and maybe even some philosophy. Let's see how far down the rabbit hole we go today. We have four wonderful speakers, and they will touch on each of these, on different aspects of this topic. So we have Anne-Marie Lummevuo. She's a legal counsel and patent attorney for Gurulogic Microsystems and former patent counsel at Nokia. And she's going to speak today about how to balance between legality and equality in multinational companies and the impact on R&D activities. Ray Millien is a vice president of Exro Technologies, and he'll speak about how to implement a compensation scheme to properly incentivize a multinational workforce. Peter Thörnquist is a lawyer for Teknikföretagen, which is the Association of Swedish Engineering Industries, and he'll talk about how compensation to the employee inventor is regulated under the agreement of employees' inventions and how disputes regarding such compensation are resolved. And last but not least, we'll have Sanna Wolk, who's union president and professor, the Swedish Association for University Teachers and Researchers. And Sanna will talk about remuneration for employees' inventions from the arbitration board, advisory board, and court decisions. So we have a great group of experts all hitting right on the topic from different points. So we're really excited to get going. So without any further wait, I would like to introduce Anne-Marie to take the stage. Anne-Marie is a doctor of IP law from the University of Turku, having written their dissertation about interfacing different employment and patent laws and multinational inventions. She's interested in exploring these interdisciplinary intersections between business, law, and technology, and currently works as legal counsel and patent attorney for Gurulogic Microsystems and was formerly patent counsel at Nokia. Anne-Marie, please, the floor is yours.
Thank you. So, hello everyone, nice to be here presenting my dissertation topic, and I will now share my slides. So the topic of this seminar is employee inventorship and compensation in the knowledge economy. And the knowledge economy surely means a lot of things, but my viewpoint will be that of patents. And the reason for that is that, as Bo already mentioned, I used to work for Nokia IPR for 14 years as a legal counsel responsible globally for employee invention related legal issues. And afterwards, I wrote a dissertation thesis based on my experiences in the company. And I came up with this. This is actually the cover page of my dissertation thesis, and it shows what it's all about in one slide. So I came up with this cake metaphor when I participated so-called 3MT competition arranged in my home university, Turku University, back in 2018 or something. And the idea in that competition is for the researchers to present their research topic to layman audience in 3 minutes and with one slide only. So in that context, then I imagined or came up with this metaphor how to explain this complex topic for people who are not that familiar with patents, but it remained to be in my dissertation thesis. So if you imagine invention as a cake, then the individual pieces of the cake could be considered as contributions of the individual inventors who can originate from different jurisdictions, which means that the situation is peculiar in a sense that even if the employer needs to take rights only to one invention, for the different inventors' parts, there can be different mechanisms to achieve that. And in my dissertation, by the way, Ulf Pettersson was the opponent in my defense. So in my dissertation, I also have a viewpoint of patenting the cake, but that is not the subject of this this webinar. So let's leave that out from here now. So because of these different laws and rules applicable to the different pieces of the cake, so to say, it means that the employer can actually get rights to the individual pieces of the same cake at different times. And I tend to say that in the US, even before the cake has even been baked, because in the US, it is possible to assign all rights to future inventions already at the time of entering into employment relationships. Whereas in countries with specific employee invention legislation, the time set to the employer to react and take rights starts when the invention has been made and reported, and the time can vary. So this means also that employer may need to pay for the rights to these individual pieces at different times, or maybe for some inventors they don't have to pay at all. For example, in the US, there is no such thing as statutory invention compensation. Whereas in Finland, the employer needs to pay fair and reasonable compensation for the rights to the invention, irrespective of whether it is patented or not. In China, the compensation is twofolded. One compensation called reward is paid when the patent is granted. Another called remuneration is paid when the patent is exploited. And then there are jurisdictions where the compensation is paid very rarely for valuable patents only. So this, I just try to give you some background to the actual topic of this webinar. So all this means that in fact there could be different price tags for the different pieces of the cake. So some pieces the employer can get merely based on the employment relationship of the inventor, while in other countries the pieces have some price tag. And the issue is that multinational companies need to balance between legality and equality, so to say. So my question is, and this is what I'm discussing also in my dissertation thesis, is whether it is possible to create a holistic approach for compensating the rights to the inventors in multinational company. And this slide shows the aspects that the company needs to take into account when thinking about the multinational compensation schemes within the company. So either the company can take into account or address merely the legal requirements, meaning the requirements derived from employee invention laws and equal regulations in national patent laws, collective bargaining agreements, or the company can also address issues like equal treatment of staff, trying to avoid so-called envy debate between inventors from different jurisdictions. Then there is a question whether paying for the inventions is considered to incentivize making inventions, whether it motivates to inventors assist in drafting patent application, resulting to high quality patent applications and also patent prosecution processes. But then there are also cultural differences and different salary levels that need to be taken into account. So of course it would be nice to pick up cherries from the cake and apply apply sort of multinational employment relationship where you have US salaries and Swiss taxonomy and Finnish employee invention compensation. But the fact is that we are living in a global world, and and in different jurisdictions, and some balancing needs to be addressed there. So here I'm providing few alternatives for the companies to address these country-specific differences in a holistic approach. So it should be possible to create a compensation scheme where there is common basis for compensating all inventions throughout the company. But the question then is whether employer wants to extend the compensation right to also those inventions that are not patented. Because, for example, in Finland, employer needs to pay for the rights also for such inventions that are not patented. So if common basis is adopted as a basis for this holistic approach, then this is the issue that needs to be thought over, whether this compensation is then extended to all the jurisdictions. Then the company could apply simultaneous payment of compensation worldwide, meaning that, for example, all inventors are paid compensation when patent application is filed. And this is actually a very common way for multinational companies to do it. But the question then is, can this compensation that has been paid at the time of filing patent application be considered to cover also the mandatory compensation payable in patent grant and in connection of patent exploitation, such as in China? And also the company could adopt holistic approach in respect of amount of compensation for inventions globally, which is typical, at least with these smaller invention rewards. But the question then is that if there is this fair and reasonable level in one country, does the company want to extend it also to those countries where there is statutory amount of compensation which is probably much less than the fair and reasonable in the other countries? And finally, I have a question. What about selective adoption of a holistic approach? So is it possible that companies would somehow apply holistic approach in respect of invention compensation, but not fully? So I already mentioned that it is possible to do that in respect of the amount of compensation and pay always the same sum when the inventor is entitled to the reward, but this would be applied based on the eligibility of the respective inventors. It is possible also to categorize inventions to different categories and then pay compensations for those inventions that belong to certain categories. For example, this already mentioned standard award for inventions that are patented or result to granted patents, because there is usually value associated with patents which makes sense in this kind of decision. Then the company can also make a deliberate decision to compensate globally inventions that relate to certain technology, or for example inventions that are standard related. And with this kind of decision, company also of course tries to direct the inventive activities to the direction which is important and valuable for the company's business. And finally, as my dissertation thesis focuses mainly on so-called multinational inventions, meaning joint inventions involving inventors from different jurisdictions, which are the most tricky one, because if the co-inventors are not paid equally in the same invention, that might cause so-called envy debate. So why not compensate inventors globally in such jointly made inventions where the co-inventors originate from different jurisdictions, one of which, at least one of which, is such where the inventors are legally entitled to compensation. This is just a question raised, and it might be favorable in terms of the individual co-inventors, but also this kind of decision could direct the inventive activities in R&D to the direction where for example, Finnish inventors are always desired to be involved because of this compensation aspect.
Great. Well, thanks so much, Anne-Marie, for kicking us off and getting us going. So now we'd like to move on to the presentation by Raymond Millien. Raymond Millien he's been named one of the world's 300 leading IP strategists by AM Magazine and a corporate IP star by Managing IP Magazine. He's the vice president and legal corporate secretary at Exro Technologies, which is an Alberta, Canadian-based public company that produces electric vehicle parts. Previously, he was the chief IP officer at Volvo Car Corporation in Sweden, and has also led the IP function at GE Oil and Gas and American Express Company, and the software legal function at GE Healthcare. So you bring in a lot of experience to the table on this issue from many different jurisdictions, Ray. So we look forward to hearing what you have to say. Welcome.
Thanks, Bo. To piggyback off Anne-Marie's presentation, and I had the great pleasure of flipping through her 432-page dissertation, which was quite illuminating this weekend. And it seems like taking that body of work and how does it translate if you're a chief IP counsel and you're working at a company and it's a multinational company and you have vendors across the world, how do you implement a compensation scheme to incentivize that workforce with the battle of the culture, so on and so forth? So I just have a few slides and some few observations, but of course, being a lawyer, especially an American lawyer, I need to make the disclaimer that, these are my personal views and shouldn't be attributed to any of my former or present or future employers. But, if we talk about a scheme, I want to sort of make it concrete, right? So if you're going to do what Anne-Marie refers to as sort of the holistic approach, or the one size fits all, as she mentions in her dissertation, what does a scheme look like, right? Because the different statutory schemes, whether it be in Finland where it's upon assignment, or in Germany, whether it's really upon usage, or whether it's in China upon grant and upon usage, you have different statutory schemes, or in a US type jurisdiction where it's just basically you're paid to invent and there is no scheme. How could you design one of these holistic approaches? So if you look at this, so this is one example, right? So you can have a disclosure award, right? And where you award a first amount for each inventor if there's sort of like less than 3, and then you double that amount and you divide it among the inventors if there are more than 3 inventors. And then you could do the same thing as a filing award where there's a second amount, and presumably that amount is greater than the first amount. So sorry for the math here, but let's either say it's X, and then you give out maybe 1.5X or 2X for the filing award. And again, if there are 3 or more inventors, you double that amount and then divide it by the number of inventors. And then you could have a third award, which is even higher than the filing and disclosure award, which is a grant award. And again, the same scheme about based on number of inventors. And then you could actually have a usage award, right? Or exploitation award, however you want to phrase that based on the maybe jurisdiction of your HQ. So this is just one scheme that I'll use to talk about designing a scheme to motivate a multinational workforce. So how do you design? So how do you actually design a holistic approach? Well, the first thing is, there are more questions than there are answers, right? So to me, what are you really incentivizing, right? There's a lot of academic debate about, you're giving out awards because you're trying to incentivize your workforce to innovate. Well, the Scandinavian countries always rank in the top 10 in the Bloomberg Index each year in terms of being innovative. America always makes the top 10, maybe not the top 5 like most Scandinavian countries, but makes the top 10 in terms of innovation. So one could argue whether you're a pay-to-invent jurisdiction or whether you have a statutory scheme, are you really incentivizing people to innovate with these awards? And the way I typically look at it is you're really incentivizing the inventors not to invent because they're going to invent anyway. To me, you're incentivizing them to sit down with people like me to actually fill out the paperwork. So they do their 9 to 5 or the 8 to 4 or 7 to 3, whatever they work. And they have to take extra time to fill out the invention disclosure, to review the patent application, to review the office actions, to review the claims, to review the appeal briefs or the opposition briefs. So to me, the incentivizing, I think people are going to invent anyway. So to me, the incentive is to do the extra paperwork. And then you talk about the culture wars or the envy debate, as Anne-Marie mentioned. But to me, is it really a question of one company, one policy? Because at the end of the day, all politics are local, and local being that company. So whether you're the logo on your chest that you're wearing on the company T-shirt, whether you're sitting in Europe or whether you're in America, you should probably try to have one company, one policy, in my opinion. And how do you do that? So you pick the most restrictive jurisdiction in which your R&D facilities sit. You design something that fits that jurisdiction, and then you work backwards, and hopefully it works for all the other jurisdictions. And typically that may result, or will most likely result, in overpaying. But at the end of the day, I think it fosters a great culture that you have one company, one policy. But there are other questions, right? Can you exclude management or executives, right? So, we've in more than one company where I've worked, we've had managers who've abused the system and have themselves named on every patent application coming out of their department. So do you exclude management? Do you exclude executives? And can you do so under the statutory, if you have certain jurisdictions in your company that have a statutory scheme? The other question is, can you be flexible? In other words, can the chief IP officer or the chief IP counsel or the head of patents, head of legal, whoever the right person is, can she have the flexibility for situations that fall through the cracks? Because when you write the policy, everything seems fair, but everything's fair until it's not, right? So can there be flexibility for extreme cases that don't fall within the scope of the policy? Do you address trade secrets, right? So the Russian law may address trade secrets, but not the U.S. But the U.S. law has no statutory scheme. So does the fact that your attorneys decide to keep something a trade secret, will the inventors who came up with that be penalized just because it wasn't something that's easily reverse engineerable, and then therefore it was decided to keep the trade secret? The last question is, what does usage really mean? Is it using it in a product? Is it using it when you license it to a third party? If it's one patent that's part of a 500 patent pool, is that usage? If it's a patent that's thrown in to make the package look better in an assertion, is that really usage? So that's another question that sometimes it needs to be addressed in your policy and falls under number 5, is it flexible? And last but not least, people don't often think about this, but if you have one company, one policy, and you decide you're going to award 10,000 SEK to your inventors in Sweden, right? And then you do and then the month that the salary is run by the payroll department, you decide you're going to do an exchange rate for the inventors, that are paid in yen in Japan, or yuan in China, or the kroner in Norway, or the Danish kroner, or the euro, or the rupees in India, right? Is the exchange rate fair? And then, I had a situation where an inventor in India called me and said, well, you're using the exchange rate, but that's not really fair. And I thought about that, and I did some research. And one idea that I came up with is, I did some research and I found out foreign exchange rates are not always fair. And payroll really hates the heavy administration because every month they have to figure out the exchange rate, what exchange rate they're going to use. Is it the last 10 days? Is it the spot rate? Is it the last 6 months? And then they have to manually do that calculation when they're using, automated payroll systems to run the payroll for the inventors when you're, in your home country. Let's say you're in Sweden and everything's in Swedish krona, and then you try to decide how many euros is that. So the idea that I came up with is, why don't we just use what the Economist magazine calls the Big Mac Index, right? Which was invented in 1986. It's published twice a year. And the exchange rate is really based on the price of the Big Mac. And the theory is that if you give an inventor an award in Sweden, and that inventor could buy 10 Big Macs, then the inventor in India should be able to do the same thing. It's a purchasing power parity notion, and it uses a basket of goods, and that basket of goods happens to be a hamburger. And I found when in one company, when I went to the Big Mac Index, we updated it twice a year. People thought that it was actually more fair when you have a holistic one company, one policy remuneration scheme. And so that's all I have to say about that for now. And I'm happy to hear the other speakers. And during the second hour, maybe we can debate whether my Big Mac Index should be the Burger King Index. Thank you.
Great, Ray. Thanks a lot. Thanks for linking to Mari's thesis and bringing it into a practical perspective. And now I'm a little bit hungry now. Thanks for that. So thanks again, and we'll get into more discussions. This is usually what happens when you go down the rabbit hole a bit. You get more questions than you started with. So next, I'd like to introduce Peter Thörnquist. He is currently a lawyer at Teknikföretagen, which is the Association of Swedish Engineering Industries. It's an employers organization representing approximately 4,500 companies in Sweden and directly employs about 320,000 people. In his role, he represents members in disputes with trade unions and or individual inventors regarding compensation for patentable inventions made by employees and acquired by the employer under the collective bargaining agreement, which is called the Agreement on Employees' Inventions, or Uppfinnaravtalet. How's my Swedish? Close enough?
Excellent, excellent.
Right. I'll hand it over to you then, Peter. Thanks.
Thank you very much for the introduction. Hello, everybody. All right, so I'm going to talk a bit about employee inventor compensation and dispute resolution under this collective bargaining agreement that Bo just mentioned. And I really like the cake analogy. And now we're leaving the holistic cake. We're not eating the whole of it. We're just looking at one of the pieces, the Swedish piece. Now in Sweden, we have a Swedish Act on Employee Inventions. It's from 1949. And that piece of legislation essentially regulates what Anne-Marie was talking about. It assigns employer rights in employee inventions in the absence of contractual regulation. And it also does state that the employee inventor is entitled to reasonable compensation for any rights assigned to the employer. So this is sort of the legal background to the collective bargaining agreement, because as you may know, in Sweden, we like our collective bargaining agreements. And of course, we have one when it comes to employee inventions. The current one is from 2015. It has a precursor from 1994, and that in turn was replacing an even older agreement. So we're talking about something that's been regulated in collective bargaining agreements for a number of years now. And it essentially supplants the Act on Employee Inventions and applies to about 85% of white-collar employees in the Swedish private sector. So I would argue that this collective bargaining agreement is actually more important than the legislation, at least when it comes to the private sector. Right. This agreement then, at a very quick glance, is essentially, like, from the employer perspective, what's most important is that it assigns more extensive rights and with less administrative hassle than what follows from the Act. Now, of course, this is important. We do want to ensure that we own the piece of cake, right? The agreement also encourages company-level system for standardized inventor awards, what Ray was describing, basically. I believe. And the agreement regulates what actually constitutes a reasonable compensation. And last but not least, instead of handling any disputes in the public courts, you go to the arbitration board. And I think Sanna will talk about a little bit about what some of the decisions that the arbitration board has made over the years. But of course, the important matter from an employer perspective here is that you are not in a public court. You are in an arbitration trial, which can be held secret, and they are secret, as are the awards or the judgments, of course. Given what we're talking about, that is, of course, very important. Okay, so over to what we're actually supposed to talk about, compensation rights. Now, the agreement is very flexible when it comes to standardized inventor awards. First of all, the agreement makes clear that any standardized inventor award presupposes a company decision to introduce such awards. Essentially, unless the company has said that we are going to have a system with standardized inventor awards, the company does not have to have one. And this might be quite different, if I understand it correctly, from the situation in other countries. The agreement does contain some recommendations on how to structure a company-level system. And the first and foremost recommendation is that companies should have one. Now, that is a should, not a must, as I already described. It also recommends that the inventor award should be half a base amount, Swedish prisbasbelopp, and that is 26,250. I have no idea how many Big Macs that represent, but I presume it to be quite many, actually. I'm sure you will get your fill at least. If the invention is of significant value to the employer's business, the inventor award should be one base amount, and that's 52,500 or even more Big Macs. And the payment should be made in one or several tranches as determined on the company level. Now, from what you understand here, if you do want to have a company level system for standardized inventor awards, even if you're following these recommendations, and I do believe many of our companies do, you still have quite a lot of freedom in how to structure it. And these systems look very different from company to company, I would say, even when they are members of Teknikföretagen and thus applying the agreement. That being said, as I said before, the Swedish Act do require that you pay a reasonable compensation, and this is something that has been maintained under the agreement. The employee inventor is always entitled to a reasonable compensation, and any receipt of a standardized inventor award does not preclude any entitlement to further reasonable compensation. So unfortunately, from an employer perspective, it's not like you can say that you pay the standardized inventor award and that's that. The agreement contains a lot of text, and it's also a comment that has been written to the agreement together from the parties to the agreement, and it contains a lot of text regarding this, but there are general factors to consider when determining the reasonable compensation, and first and foremost, I would say, is the value of the invention to the employer. It's also the scope of the rights assumed by the employer. Now, I would say, in my experience, it's very unusual that the employer doesn't assume all rights to the invention. It's very difficult to see why you would do something else. But in the event that the employer says that, well, actually, I only need the right to, license this for a period of time or something like that, then that is, and the employee is then allowed to use the invention in any other form, then of course that sort of affects what the reasonable compensation should be. Further, of course, the employee's position and compensation package is relevant when determining whether any further compensation should be paid. And lastly, the employer's decision not to patent the invention does not as such affect the right to reasonable compensation. Now, what this means is that if for business reason, the employer finds it more valuable to the business not to patent, but rather just use the invention in the business without revealing it to the world, then that is not something that should affect the employee's entitlement to compensation. Very often, of course, the employer decides not to patent the invention because it is deemed not very valuable. That, of course, is something else. That is proof that the value of the invention is actually quite low. Anyway, reasonable compensation is normally not determined as royalty. I think that's quite interesting. Some very clear language to that effect in the comments to the agreement, and also, for that matter, in the text. But this, well, I think Sanna might talk about the recent case, and I just wanted to highlight the fact that under the agreement, reasonable compensation is not the norm. However, reasonable compensation is not the norm that you have it as a royalty, except for exceptional cases. And those named in the agreement is when the invention more or less constitutes a product or service. I mean, we're not dealing with complex products in that case, or complex services, or when the invention has been licensed or sold, you can very clearly see a revenue stream from that sale or that license. So, moving on, when we're discussing reasonable compensation under agreement, we have to discuss A inventions and B inventions. Essentially, A inventions are inventions made in the ordinary course of work. Ray talked about people being hired to invent, and they will invent nonetheless, so to speak. Well, these are the kind of inventions they produce. And the starting point there, of course, is that these people have been hired to do work that results in patentable inventions. And from that point of view, the compensation package that they do receive under the employment agreement and the collective bargaining agreement and so on, together with the standardized inventor award, that is reasonable compensation. However, further compensation may be required if it's a clear mismatch between the value and the invention and employee's position and compensation package. I would argue that it has to be beyond significant, betydande in Swedish, for further compensation to be relevant. Somebody might have a different opinion. B inventions are any other inventions, and here the starting point is the opposite. Further compensation should be paid unless the invention is of limited value to the employer. And this is something you will see quite a bit in negotiations regarding this, that we want it to be an A invention as an employer, whereas the trade unions might want them to be B inventions. Right. What actually constitutes reasonable compensation in the individual case is determined through an agreement between the employee and the employer after the invention is made. Now, if you agree with the employee that this is reasonable compensation, then that's that. If you cannot agree, there is a dispute resolution mechanism. And that looks like this. Negotiations between the employer and the employee inventor. If it's a unionized inventor, the next step is trade union negotiations at the company level and then at the central level. And lastly, there's a trial before the arbitration board. Now, if it's a non-unionized inventor, you go straight to the arbitration board. And a call for trial must be made no later than 10 years from the first patent applications. So as you understand, these are issues that can pop up quite some time after the actual invention is made and the patent application has been made and so on. And of course, when it does actually pop up after some time, it's usually because the invention has been part of a successful product or service or something along those lines. Now, I'm going to really quickly just mention a few things about negotiating a dispute, because that's what I do, right? I represent our member companies in these trade union negotiations. And it's really typically sort of boils down to whether or not, well, the value of the invention to the employer. And there are any number of arguments you can find in favor or against, but that is really what we're talking about usually. Now, has the invention been sold and licensed and the trade union or the employee knows about this, then that, of course, is interesting to them, and they will want to know whether or not the price was right, so to speak. What have you actually earned from this sale or licensing? Now, typically, this is not the case, but rather that the invention has been used in products or services, and that they, in turn, are generating sizable revenue, basically. And in these cases, of course, we tend to argue that, sure, this has been a product or service that is incorporating the invention, but and maybe we can't deny that the revenue is sizable from these product services, but then you kind of try and focus on the invention not being of particular important to the success of these products or these services. It's a complex product. Now, we heard Ray used to work for Volvo, right? Now, cars are complex products. They do contain various inventions typically. And in such a case, an argument, of course, would be that the customer is not buying this particular technical solution that the inventor has made, but rather the whole package. So it's really not that much of, let's say, legal finesse. It's more like really getting into understanding the business, understanding the products that's being sold, and whether or not this is actually important or not. I believe I am soon out of time, so luckily this is my last slide. Like Bo said, this is Teknikföretagen, right? We do have a lot of white-collar employees inventing a lot of stuff for our member companies. A large number of patentable inventions are made every year, and there are very few disputes regarding reasonable compensation. Teknikföretagen used to have about 3 to 5 such disputes, either in negotiations with the trade unions or in the arbitration before the arbitration board. We're now, since 2016, down to 1 or 2 a year. So I don't know exactly why, but for some reason, the system seems to work. People seem to be reasonably happy with the awards that they are granted, at least happy enough not to try and get more through this dispute resolution mechanism that we have. And if you really paid attention, you will note that 2015 is when the new agreement was reached, and 2016 is when we saw this drop from few disputes to very few disputes. I don't know if it has anything to do with agreement. The rules in this regard regarding compensation didn't really change that much. So I don't know. Maybe somebody else has some idea. And that was what I had to say. Thank you.
Great, Peter. Thanks a lot. That's interesting. You have statutes and you have them across different countries, and then you have a collective bargaining agreement between different actors here, and whether that makes it easier or reaches some type of agreement, like you said. Is that better or not? That's an interesting question. Now I'd like to introduce Sanna Wolk, and Sanna will probably talk a little bit more about when things people don't completely agree, and what happens and what comes out of that. But Sanna Wolk is professor and arbitrator and union president of the Swedish Association of University Teachers and Researchers. She has written a number of academic publications on this topic, and most recently published the 3rd edition of her book, Employees' Intellectual Property Rights. So you've written the book on this subject, Sanna. So it's great to have you here, and look forward to hearing what you have to say. Thanks, Sanna. Over to you.
Thank you very much. And since this previous speaker has been talking about the framework, I will mostly just talk about the amount that is actually paid to the inventors. But first, a short recap. As Peter mentioned, we have the Act on Employees' Inventions, and then we have collective agreements, one from 1995 and one from 2015. And there is a very, very distinctive change in those two agreements as regard when you can file for an action to actually claim remuneration. We will have 2 agreements that are parallel until 2025, the 1st of January, I think, 2025. I don't have the agreement before me. But what is different with the new agreement that now you have 10 years to claim reasonable remuneration from the day that the patent was submitted to the registration office. And that's a huge difference, because usually when you gave notice to your employer about an invention, and it usually took something between 3 and 8 years before the patent was applied, and the right to claim remuneration was connected to when you had notified your employer. Now it's changed. Now it's when the employer will file the patent. The old system you only have if it's not going to be filed and it's just a patentable invention. And this is why we don't yet actually have so many arbitrations, so many cases submitted to the arbitration board, because it's always better for an employee to wait as long as possible, because then you also really know the value of the invention. But before, you had to rush, and usually the invention has just been patented for perhaps 1 to sometimes 3 years, and you didn't know really how much work it was for the employer, and how much business the employer could gain on the patent. So this is one of the hugest reasons why employees are waiting to claim compensation under the new agreement. They have time nowadays. So that's the biggest difference. And then if you look at the amounts, it's varying a lot. It's varying a very lot between different amounts, from 0 up to millions for an invention. We have this case from the Patent and Market Court that Peter mentioned. I will soon talk about. The arbitration board is under the collective agreement. Then this is the it's a governmental board, but they are giving just recommendation, not decisions. But usually parties are following the recommendations. And what is interesting that the change, when we actually change and the employees started to receive millions in remuneration, is from the arbitration board in 2002, when actually an employed inventor received 5 million Swedish crowns. And this was not decided in this court decision if it was arbitration decision, if it was A invention or a B invention. They just said this is an invention that the employer have earned more than 800 million crowns on. So it was reasonable, the claim on 5 million crowns. Then we have had some other different, both district court cases, arbitration board cases, and also from this the governmental but recommendation board, if you could say it like that. What is, I would say, the most interesting decision since after this decision in 2022 is this one from 2013. And it was not the amount that they received 6 million crowns. It was actually a previous decision, because this was a never-ending story. The inventor were recommended to get the 1.5 million Swedish crowns 1986. This never-ending story actually ended 2013, and they received the same amount, but to the days or to the 2013 levels. But what is most interesting, I mentioned just 3 decisions. I think there were 4 different decisions in this errand. But this is one from 2007, because that was the question: are you, as an employed inventor, could you have also compensation if a patent would be invalid after a time? And they actually said, this board, that it was that the inventor should have compensation for the time that actually the patent right was registered. So in this case, it was 10 years. And after that, it was made invalid patent by the court. So I think that is very interesting, and you should bring that with you when you are considering employees' right to a compensation. After that, I think the most interesting court is that now from the Patent and Market Court in 2023. It's appealed to a high court, so this is not the final judgment. But what is interesting in this case, it's one of the first high court decision that we have had for ages in Sweden under the Act. We had some in the 90s and the 80s, and that's because we had a period where we didn't have any collective agreement. So that's why we had quite a lot of court decisions. But they are old, and so this is a fresh new court decision. In the district court, the inventor didn't receive any compensation. But in the Patent and Market Court, the higher court, Patent and Market Higher Court, it should be there, it was decided that the inventor should have almost 4.4 million Swedish crowns plus royalty approximately for 10 years. And this is the first royalty decision we have seen since I think it's the 70s. The arbitration board, as well as this the other board and also the courts, always have determined the compensation to be a lump sum, and always saying that there are no trust between the employer and the employee, so that we shouldn't have a royalty and instead a lump sum. And this is very interesting. And if there are trust issues or not, I can't judge. But it's always complicated when you have a royalty because you open up for ongoing litigations related to the royalties. And what is also, if you count on this decision and the royalty and just look in the back mirror, the lump sum that it would be, if they decided a lump sum, would be almost 90 million Swedish crowns. So this is also a very, very, very high amount that the Patent and Market Court, High Court, have decided. I'm not so sure that the Supreme Court will end up in a similar decision, but we will see. That's going to be very, very interesting. And this is everything I wanted to talk about. But as you see, the sums are very different. We don't have so many arbitration board decisions, and the most common is actually that there are a lot of discussions between employees and employers, but the normal is that they are deciding together, agree together what is a reasonable remuneration. And I think you're going to have the slides later sent out by Boom, and I added just 3 pictures so you can also see what is claimed and what they actually received, the employers, from the this is in Swedish because it's from my book, from the courts, from the arbitration board, and also from the board, recommendation board, we can call it. So that's what I wanted to talk about today. And I think, and this is my book that is just new, fresh on the market. And now it's almost 5 o'clock and we're on time. Please, Bo.
Great. So thanks a lot, Sanna, for taking us through that. I know it's interesting for people to see in the end of the day the numbers and of course the spread of numbers, and as we listen to the agreements and the incentives from the other discussions, how does this actually come out in the wash? How is the text actually interpreted by people and agreements made, and how much money are we talking about? So thanks a lot. To end this now, I would like to thank all of our speakers for sharing their knowledge and insights today. So please stay connected with CIP through our LinkedIn page to learn more about future webinars and other CIP activities. Thank you for tuning in to CIP Forum Overtime. Until next time, take care of yourself.